Bismillahirrahmanirrahim, dear students. The next lecture is on police reformation for 21st century functions. In 1947, people of Pakistan established it as a separate country out of the Indo-Pak subcontinent uh, for peaceful existence and prosperity by indigenous policing on Islamic patterns without corruption or excesses. The perfect execution of penal laws in Pakistan for proper rule of law in the Punjab under Police Order 2002 or Old Police Act 1861 in other provinces has certain prerequisites of changing police culture. Broad-based reformative for 21st century police adoptions are must to operate to people's expectations, making Pakistan a prosperous nation. Peace is basic police role for national development. Police in all provinces of Pakistan divides offences in monthly, quarterly, half yearly, and annual reporting in varied categories. Police must be alert for all crimes in view of this. Uh, Police crime classification needs police operation officials and investigation executives may have their easy grasp of crime type with perfect police report to concerned court under CRPC as not severity of law but surety of the court punishment is. So, CRPC Criminal Procedure Code has a significant role in this regard while the police are performing their duties during the criminal investigation. Victim categorization by classes of crime. All the 145 penal laws can be unified into one new code as the updated Pakistan Penal Code 2020 in one part in one class called easy grasp of the law and forces in the states. The applications can be decodified and a lot of separate penal laws with counter sections can be integrated. Legal implications and complications. Delay court decisions. Delaying justice is denying justice. So, uh, many adjudicators and many police. Present Islamic Hudud laws, as well as the Qisas and Diyat provisions, are adjudicated by session judges or higher class judicial magistrates. General penal code provisions are tried by the civil judges, come junior judicial magistrates. Custom and excise violation of laws are tried by custom courts. Banking penal laws are tried by banking tribunals. Specified terrorist and index crimes penal provisions consequently are tried and can be referred by Prime Minister for trial in special terrorist activities, speedy trial courts. There are separate national accountability courts under the National Accountability Ordinance 1999, uh, updated to 2015 requirements. Local laws violations, that is traffic and municipal violations, are tried by summary magistrates. Canal magistrate try canal act breaches. Railway violations are tried by railway magistrates. Electricity violations are settled by WAPDA magistrates. Municipal rules breaches are tried by municipal magistrates. Motorway highways fines are settled by their own systems. Multiple components of judicial forums is negation of uniform adjudication of local violations of local judge to redress grievances of victims by offender in a particular locality. So, high cost process in these faraway courts is followed by multiple appeals in higher courts on still higher courts at much more distance. So the justice is very costly. It involves too much delay far away from the poor victim, as such multi-organs of police deal in their own components, such as specific code violations in specific judicial forums to uphold by functional action the rule of law by modernization, registration, and investigation mess. A crime is a situation where victim has his her own story in the FIR, that is first information report lodged with the police. Each police executive with Thana Scribe has its own bent of mind to apply what sections of which code for the occurrence reported by the victim is to be applied. Investigation is to be carried out by new wing under Police Order 2002. Circumstantial evidence has its own value. Laboratory reports provide good clue. Every factor should be taken into consideration. Eyewitnesses have their own version. Medical, legal, and post-mortem reports, as well as DNA report and autopsy report, have their own pivotal impacts. Every police investigator has its own strategy for the process of each case by his own method or procedure, by his own bent of mind. Cross-examination in court by the defense attorney about facts is recorded by the police investigator, and all the witnesses and evidences are presented to prosecution as victim proof to defend the investigation of case. All this process can be held futile by the judge or magistrate. Human rights are seriously damaged. Accused and placed judicial custody in prison indefinitely against the law and the constitution. Illegal arrests, illegal detention. The police arrest of suspect, the build up of confidence of the victim of his or heirs in investigation, and reinvestigation is carried to factfulness but with benefit of doubt to the accused person. The defense counsel has his or her own tactics to prove offender's innocence to get him or her released by honorable acquittal. The suspects don't submit facts in normal police interrogations expected by the victim or the investigator. No clue achieved. Usually, no clue is achieved within 24 hours of the occurrence as stipulated by CIPs. Arrest of more than 50% crime suspects become impossible. After arrest, every suspect accused is to be taken to further interrogation to complete investigation. That final challenge is submitted to the court in the light of the FIR within um, 14 or 15 days, Section 173 CRPC. But it is never practiced as prescribed for police reinvestigation, which itself is a negation. So justice must be imparted by speedy and inexpensive process as granted by Article 37 of our Constitution. Uh, as basic human right, it must be made a functional reality as the 21st century aspiration of the people of public suspicion. The work of police, whether of FIA or of anti-narcotics force or any other law enforcement agency, is surrounded by public suspicions as policemen indulge in so many malpractices and are not so efficient. Victim complaints are not attended without pressure. Arrests are not effected even in cases of victim nominated culprits. Those arrested are dumped in police remands. They are ill equipped in modern methods of investigation and pragmatism. Therefore, in our circumstances, police resort to repeated physical remand from the court of protection. Rather, they try to keep suspects in fully unjustified illegal detention in dungeons and use third degree methods in their so-called drawing rooms, either to extract money and discharge accused or to get court permission to further investigation and ultimately reach the real offenders. Thus, justice is dubbed under uh, hibernation uh, too much delay for victims' dismay. The youngest criminal adjudication is done by NAB with enough funds and staff and their own. So the too much delay is faced by accused on all the NAB levels. Under Article 9, 10, 13, and 14 of the Constitution of Islamic Republic of Pakistan, 1973, as a fundamental right, no citizen can be tortured, deprived of security, unduly arrested, or detained or self-incriminated during investigation and interrogation. These are the rights of the accused. Any citizen can't be subjected to any sort of torturous method. Such person can get home force and be kept only in police lockups in full view of public if detained after due process. His or her physical presence will be noted in the Roznamcha, daily diary of police, which is not done. Women can be kept in the police custody for investigation during daytime only. Uh, Section 167 CRPC has been modified by the Parliament that a female suspect can be taken to custody only by ladies police for 24 hours, and no male police officer can keep them after such set for investigation. And no male police officer can keep them after sunset investigation. The Supreme Court has already imposed ban on autopsy and postmortems of females and dead body by males, but it goes on that few lady doctors opt to such. Under the United Nations ratified Child Rights Convention (CRC), Child Rights Convention, no child below 18 years in age can be kept in police custody beyond 12 hours in daytime as prescribed under the Juvenile Justice System Ordinance. But they are kept in police custody unnecessarily without any justification. Therefore, police operations must be reorganized, rehabilitated, reorganized, reformed to modernize with reference to the changing challenges of the modern world. Police legal duties in geopolitics. Following are the legal duties of police in geopolitics. So, some of the basic points are very serious with reference to the geopolitics. Uh, Section 61 of the CRPC, read with Article 10 of the Constitution, as basic police obligation, makes it mandatory that a man should not be kept in police custody in any case beyond 24 hours without permission of the court having jurisdiction. The physical remand of the accused or suspect for only 12, 14, or 15 days under Section 167 CRPC will be allowed by concerned magistrate, area magistrate, but police does not follow these provisions so strictly by such negligence. They are violating their new police order, which prescribes uh, serious action against them. So, Article 10 of the Constitution or Section 61 CRPC के मुताबिक किसी भी arrested बंदे को आप 24 घंटे से ज़्यादा without the warrant of the court जो है वो आप नहीं रख सकते और अंडर सेक्शन 167 CRPC आप ज़्यादा से ज़्यादा 15 दिन का जो है फिजिकल रिमांड एक्यूज्ड का ले सकते हैं इससे ज़्यादा नहीं. Section 67 of the Criminal Procedure Code is very clear about the custody of a person arrested by police for only 24 hours, after which she will be produced before the magistrate of the jurisdiction. Investigation and interrogation of police should be completed in 24 hours of arrest, but due to over preoccupation and workload of police investigator, usually an assistant sub-inspector of police keep such suspects in their private detention to torture them beyond jurisdiction in violation of human rights and constitutional guarantees ensured to each citizen of Pakistan. So this is severely punishable under police act. If the police can't submit challan within 14 or 70 days, such persons can be bailed out by the court even if involved in a murder case. It is not known how inquiries of cases are delayed for months to submit police challan. Finally, the public is much frustrated as to why concerned courts don't take notice of this police violation of Section 167 CRPC to start trial. So 173 CRPC के तहत जो चलान है वो 15 दिन के अंदर मुरतब होना चाहिए, 2 वीक्स के अंदर। और यहाँ तो महीनों जो है चलान को डिले किया जाता है, दैट इज द मेल प्रैक्टिस ऑन द पार्ट ऑफ द पुलिस। Section 159 and 190 CRPC provide that the magistrate or any court having jurisdiction should visit the spot to take notice of an offence immediately and institute inquiry about any crime committed under any section of PPC. These codal and mandatory provisions must be followed after 155 years of their legislation. काम ही है तो मजिस्ट्रेट जो है वो स्पॉट को विजिट करें या इंक्वायरी जो है वो लीगल तरीके से जो है वो कंडक्ट करें। Section 344 of CA provides that due to the reason beyond control of police, maneuvering the court can allow them to complete investigation and extend the interrogation to get more facts beyond voting. So this is just in good faith to reach the reality and submit challan within stipulated period. So this challan submission period extended by courts must be rectified to start trials within 3 weeks to record fresh witnesses as required from Islamic jurisprudence. So 344 के मुताबिक जो है अगर 2 वीक्स के अंदर पुलिस वाले अपनी इन्वेस्टिगेशन कंप्लीट नहीं करते तो फिर अदालत को इख्तियार है कि वो 345 CRPC के तहत जो है वो मुलजिम को जेल में भेज देते हैं जुडिशियल रिमांड पे, दैट इज इन द कस्टडी ऑफ द कोर्ट। The delay tactics are maneuvered by the accused and his defense counsel so that the prosecution, the victim, the circumstantial evidence, the eyewitnesses, post-mortem, the doctor's evidence, the report of the chemical examiner, police witnesses, and all other facts of the case are made so stale and out of context that court adjudication becomes a futile exercise. जितनी ज़्यादा डिले होगी प्रोसिक्यूशन केस में उतना ही ज़्यादा जो है वो प्रॉब्लम्स क्रिएट होंगे और चलान में डिले, फोरेंसिक लैब की रिपोर्ट में डिले, इन्वेस्टिगेशन में डिले, तो ऑल दीज थिंग्स वुड बी fatal for the dispensation of justice. The courts must play their punitive role to rediscipline police. Courts must use powers of Section 248 to 250A of the CRPC to punish falsely implicating complainants and release the innocent. कोर्ट्स को जो है वो सेक्शन 248 से सेक्शन 250A तक CRPC के तहत जो पावर्स हासिल हैं उनको जो है यूटिलाइज करना चाहिए to play their positive role to organize these malpractices, to root out these malpractices, to abolish these malpractices. The police rules are clear about the powers of the SHO and senior officers of the police, as well as the powers of the magistrate to give full opportunity to the relatives, friends, kith and kins, and the defense counsel of the suspect, accused, nominated offender. Police can't keep such suspects confined in tortured dungeons or killed by extrajudicial process of police encounters, quite contrary to the Islamic justice, Constitution of the Islamic Republic of Pakistan, and the human rights principles and conventions. How it can be carried by our police under their new police order as a system of colonial torture of the 19th century. So, therefore, 21st century Pakistan needs total reactivation of the police functioning for their law enforcement operations to people's aspirations as prescribed in the Constitution and statutory and place legislation.